I have filed the writ petition since respondents.
32 is not maintainable. How can you get a quashing order of a judicial proceeding under 32?
Sir, because
Sorry, sir.
sir, 1 minute, sir. Sir, I have filed a quash petition in High Court, sir, but it is not pending.
Quash petition will be decided on its own.
But it
merit.
was
But
not
you
for.
can't file a 32 for quashing judicial proceedings.
Sir, actually, it is a violation of fundamental rights, sir.
Since
For
the,
that you have a remedy.
since the petitioner has approached.
But in High
Which court have you approached with the quash? High Court of?
Andhra Pradesh.
High Court of Andhra
Yes,
has
sir.
approached the High Court of Andhra Pradesh with a petition for quashing of the judicial proceedings, comma. This Article 32 writ petition is not maintainable. Seeking similar relief. Dismissed.
So
This order of
kindly, sir,
shall not preclude the High
allowed to
Court
file in a High
from
Court, sir.
deciding the quash petition in accordance with law.
Please, my lord. 41, my lord, this MA is for recall of your lordship's order.
I don't understand these
My lord.
is recalling order.
Yes, my lord. Let me demonstrate what has happened.
No, no.
Permit me to at least, my lord, demonstrate.
No, no,
Permit-
this is abuse of the
No,
process.
no, it's not abuse.
We will dismiss it with cause.
My lord, just give me one opportunity at least, my lord, demonstrate.
Sorry. We will not entertain this application. Why didn't you file a review?
My lord,
You have filed a review.
my lord, the whole difficulty was
No.
second May.
Whatever be your difficulty.
My lord, I have annexed the order
Whatever
when your
difficult-
lordship had permitted me to file
MA is
at.
absolute abuse. Sorry, next.
My lords, may kindly pass it over.
Pass over.
My lord, please see page number 21, my lord. This is the certificate issued by Tehsildar about which they are saying that it is forged, my lord. Investigation was done by police before issuing that. My lord, please come on page number 21. It is a Hindi document. 22 is the English translated document, my lord. And before that, my lord, please see report. It is, my lord.
Why should we consider your claim at this stage?
My lord,
What is the
is
prejudice
no
you have
evidence.
suffered? What is the prejudice you have suffered? If there is no evidence, you file an application for discharge before the court.
And my lord, there is no case against
No, no.
the petitioner 1 and 2. My lord, please see.
Dismissed.
Only one submission, my lord.
We are not the tribe.
Only one submission, my lord. This is
Don't convert the Supreme Court into a court which
No,
will
no.
go into facts
two,
as the first
two
court. Sorry,
ladies.
sir.
There is no name of two ladies, my lord.
Next matter.
Two ladies have not even applied, my lord, the certificate. Please see
44.
only once, my lord. The
We are not
innocent
interested, sir. We are not interested. Because no prejudice has been suffered by you. You have just been summoned and you don't want to face the proceedings.
That is what,
Well,
my lord.
is
I am
it the end
before
of the
my-
road for you? Is it the end of the road for you? Law does not provide you any other remedy
But my lord,
that you will have to come to 136 jurisdiction?
falsely implicated, my lord. There is no evidence
Which
against me.
criminal says that he is correctly implicated?
No, my lord. Please see the document.
Which criminal will say?
Evidences are on record, my lord.
Sorry,
Sorry.
we are not entertaining under 136.
My lord,
136 is not for that purpose, sir.
two ladies have been falsely implicated, my lord. Those even were not named in the
Next
family
matter.
certificate, my lord. Falsely, my lord, a liberty to go before trial court, my lord, for the bail, my lord.
Who has stopped you? Who has stopped you
Well,
from
after
applying for
coming-
bail?
After coming here, my lord.
After coming
warrant
here, that
has
means
been-
that you will not be
bail warrant
granted
has been
bail.
Issued, my lord.
You will not be granted bail.
Yes, call the next case, please.
Obviously.
Lordship, this was not a private.
So is the complaint, whether it's 156.3 or 200.
Yes, my lords.
Where is that?
Yes, my lords. That is at page 50.
50.
50. And there is order by magistrate also.
There is a statement in this 156.3 that I intended to lodge an FIR. The police did not accept it. That is why I am coming before you, magistrate. Please come to page 57, para 10.
Yes, my lords.
Last sentence. Therefore, this honorable court has the jurisdiction to inquire into the complaint and
Para
pass
9.
appropriate judicial. So,
Para 9.
huh?
Para 9 is,
This is a private complaint.
my lords may just
This
see
is a
para,
private complaint, not a complaint under 156(3).
my lords may see para 9.
Para 9.
The complainant attempted to lodge a complaint regarding the offence committed by the accused at the concerned police station. However, the said police station expressed its inability to accept the complaint. Therefore, the complainant submitted a written complaint to the Police Commissioner Nashik, as well as to the Joint Commissioner Nasik Road. Despite this, no action has been taken on the said complaint to date. Hence, the present complaint has been filed before this court. Now, my lords may come to the prayers as well. Page 58.
Yes, prayer is there. Prayer is there. Very good.
Thereafter, the order.
Notice
My lords, there are two requests. This is permission to file SLP that may be allowed. And,
granted.
yes, my lord. And Dusty in addition, with liberty to serve standing.
Right. Next.
Grateful, my lords.
May I please? So I appear in 45 and 45.2.
Allowed.
Connected matter notice has been issued, my lord.
Connected matter notice has been issued.
Please, my lord.
That is why.
Filed by co-accused, my lord.
अच्छा इसके साथ कनेक्ट कीजिए मैडम.
There is one difficulty, my lords. All the accused have surrendered, except for
Huh?
all the accused have already surrendered, except for Solai Raja 45.2 is not surrendered. Lordship may direct him to surrender because I've already instructed him. He's yet to surrender. Lordship may
Why
direct.
should we direct? You surrender.
Please, my
We
lord.
will not direct anyone.
Please.
45.1 also the same order may be passed.
Then 45, all 45 and connected matters to be tagged with the other one.
May I request for notice on bail, my lords?
Notice on bail.
Grateful, my lords. Deeply obliged.
Notice on bail. Next, 46 adjourned as per letter.
With respect, I'm objecting
You are
to it.
objecting.
Yes, my lord, may kindly see, my lord, he filed it on 4th of September 2025. 9 months he has taken, the matter has not been taken up. My lord, because he's not allowing the High Court to proceed with the matter of the other co-accused. And my lord,
But there is no interim order, madam.
my lord, this
Is there any
it has
interim
not
order?
been heard. My lord, this matter has not been heard till date. Last time also he said he's not well, adjourn it for 2 weeks.
My lord, it is second date before this court, my lord.
My lord, kindly keep it for a fixed
Monday.
date.
Come back on Monday.
My lord.
Obliged, my lord.
Lord, I have seen Lalita's judgment, my lord, indicated by your lordships last time.
Huh?
Lalita's judgment,
Uh-huh.
your lordship's judgment. But here the rule itself has been struck down in another case. My lord, kindly see page 112. The rule which provides for 45 days time to apply for inclusion in the local cadre itself has been struck down, against which a writ petition is pending in the High Court. Page 112, para 17. Rule 6, which provides an outer time limit of 45 days for inclusion in the local cadre itself has been set aside. Para 17, against which the department has gone up in writ before the High Court.
When did you move the High Court?
My lord,
2025?
my lord, I moved the,
2025?
yes,
The High Court has also rejected your claim on the ground of delay and laches.
yes.
How do you satisfy her?
My lord, a lady, my lord, who was on maternity leave,
Very good.
then she was under
Right.
orders of transfer. My lord, the rule itself has been struck down.
Very good. Dismissed.
My lord, liberty to challenge the rule may be kept intact.
Nothing. Sorry.
Please go on.
देखा है?
Just 3 points essentially.
Notice, stay.
Stay. I am grateful.
Without issuing notice in the matter, my lordship has directed us to seek instruction regarding the proceeding taken place before the Honorable High Court, my lord. Where the case is, my lord, the amicus queer learned amicus has appeared for the appellant.
He was in jail.
He was in jail, my lord.
His counsel was not there.
His counsel was not
So High Court engaged an amicus.
amicus, my lord.
So was he ever communicated?
My lord, he was in
counsel is-
jail. But
He was in jail doesn't mean that he is not entitled to communication.
no,
Was he communicated that your counsel is not appearing? High Court proposes to.
it doesn't born from the record, my lord. The record
It is
only
not born
suggests-
from the record.
record only
It's not
suggests, my
born-
lord. the-
How long have you been there?
My lord, 6 years,
Huh?
as per custody certificate, 6 years.
6 years.
More-
Where is our judgment on that amicus matter? You have it? In the Jharkhand matter, we have passed an order.
Yes,
You have that judgment with you?
Don't have.
You don't it? Don't have it?
But I have read that. Don't have now.
Could have brought it today.
May kindly.
For orders on Wednesday.
My lordship is remanding back, my lord, or
Yes.
We'll do that.
as per that grateful man.
We'll do that.
My lords, this is a case regarding brutal murder and rape of a physically challenged girl, my lords. And my lords, he is a criminal offender. He has a criminal history of various cases. Some attempt to rape, some attempt to murder, some grievous hurt. Everything, my lords, he is there. Even under Arms Act, he has a criminal history. My lords, I have the list of the criminal history of the offender.
Don't notice.
Obliged, my lords. My lords may allow the physical appearance if possible. Obliged.
My lord, single judge dismissed it, saying the writ remedy is not available, and division bench says, my lord, writ remedy is available, and they directed it in respect of a private dispute. Lordship has held in number of judgment, my lord, where writ court cannot entertain this title disputes. Master. Para 28 of this, your lordship judgment, my lord. Para 28.
It's like High Court exercising 142. What is the wrong?
Look, my lord, it is a title, my lord, this is a title dispute.
You stand to lose, sir.
My lord, your lordship kindly see.
You have been asked very well.
Yes,
You have been
I have given undertaking.
liability of 25%.
Yes, my lord.
That will not go to him.
My lord,
That will be invested
my lord, your,
in a
my lord, this,
deposit,
my lord,
so that ultimately, nobody knows when the
my
matters
lord,
will.
my lord, I have given undertaking. My lord, yes, not.
Not an undertaking, Mr. Mani.
My lord,
On the whole, it's a
my lord, you,
justified order.
lordship, but your lordship may give one.
Sorry, we will not. On the whole, it's a justified.
Permission to give my physical appearance.
Yes.
My lord, we are seeking a passover in this matter.
Passed over.
Much obliged.
This your lordship heard on the last day, cancellation of warrant, my lord, of a British citizen.
Let us see. 53.
Your lordship, I'm seeking a passover. I'm led by
Who
Mr.
is not the
Parkes.
petitioner? What do you want?
Passover may be granted.
Passover.
Please, my lords. My lords, it's a case of conviction under 302, my lords, life imprisonment. And my lords,
Chopped off his head.
my lords, there is no evidence to
There
that.
is
My lords,
PW10, PW14,
my lords,
PW15.
they all are,
And you are named in FIR also.
my lords, they are all are interested witnesses, my lords. And
Interested
in
witness.
FIR, in
Suppose
the,
a murder takes place in my house, I am an interested witness and no conviction can take place.
my lords, there is no corroboration.
What
or-
to know?
If I-
There's direct eyewitnesses, P10, P14 and P15.
My lords,
That's why you have your name.
there is a delay in the recovery of the body as well.
This all.
There
should
is
stop.
there is a 3-day.
That two of them because there was an allegation
My
that
lords,
he's practicing black magic.
My lords, there
No,
is
there's
a
nothing.
delay.
I'm sorry.
My lords,
Yes, sorry. Very sorry.
my lords, he has undergone 14 years now, almost 14 years. He's a,
What is the period of custody? Just give it.
my lords, 13 years and 9 months, my lords,
Take
now.
time,
And he's a young man, my
He
lord.
has undergone 13 years.
Please.
Then he will be-
Our observation is that the superintendent of the jail, where he is lodged, he will move the appropriate government for securing his release, subject to eligibility.
My lords, please, my lords, I bow down.
Yes, 55. Mr. Diwan, is the High Court on vacation?
Yes. Yeah, so may I just indicate what happened?
No, when it is reopening,
No, it has been listed now for 23rd June.
23rd June,
Yes.
that is why we are asking you.
Eighth
Yes.
reopens. Eighth, my lords.
8th June,
Yeah.
8th June.
Yeah. So in the meanwhile, my lords, we need a little protection. So can I just?
Why are you disposing of properties that is their
Disposing
allegation?
of like,
Disposing of this order that my learned friend has challenged, I have an order stay of these proceedings in two other petitions, my lords, which I have challenged, which is not in challenge before your lordships, my lords. In those, now whether he is an aggrieved party or not, it has to be determined by.
Has to be determined, but since we adjourn hearing, noting that the matter is coming up the next day,
Yes.
the High Court.
They sought time. They
No,
sought
we
time.
haven't sought
Who sought
time.
My
Not at all.
counsel, my
On
counsel was
21st
there.
April, the matter was stood over. We placed your lordship's order on record through a memo. It was placed on the 23rd of April. 23rd of April, the court didn't sit. It was listed on the 24th of April. And on the 24th of April, it has now gone to 23rd June.
On 24th is when they sought time. The counsel is appearing here. He was there in Hyderabad, and that is what they did. They sought time, and then there were other two petitions.
Is the order recording that?
No,
No,
we
it
placed
doesn't
on
record, but they sought time.
We have
my lord.
placed it,
Many times your lordships record. Now, the writ petition came to be filed, my lords, asking for the same prayer, which was dismissed by the High Court, challenged till your lordship's court, which was also dismissed, asking for the same prayer. Now, two of those petitions in which I have a stay, they have not challenged that before your lordships, my lords. Where the two members have held against me, that is stayed. So today, whether my learned friend's client is an aggrieved party or not, whether RERA has authority or not, my lords, is a question that is still to be gone into.
So let the High Court go into it.
I'm
That
not
was the
stopping,
purpose.
But look at
That was the purpose, but if the High Court, we understand that they are under immense pressure, no doubt. But when we have urgent noticing that the next day was the date for hearing, the High Court doesn't hear it. Why?
But my learned friend's client should have disclosed, or the lawyers there should have disclosed that there are two other petitions which I have challenged. They all have to be done together, my lords. It can't be heard in a piecemeal manner. Your lordships do that. Every time, all petitions have to be heard together. Now, against the same order, my lords, when my petitions are pending there, and this person whom Mr. Diwan is representing, my lords,
Mr. Diwan, if in the meantime he does anything which prejudices your client, this can always be brought to the notice.
So now, let me open my case. Let me allow.
We are not allowing you to open your case.
No, but I must be allowed to open the case.
We are inclined to keep it beyond 23rd June.
This matter. But now let me just explain as to why this order. So I'm requesting two things. One is your lordship made a tentative observation. So just let me make that statement over here as to what I'm requesting. I'm requesting a stay of the impugned order. And number two, I am requesting because my application before RERA was for an allotment of property because the construction is coming up on my land or 2 acres of my land. Now it can't be that I am the owner of the land. I am entitled to 21 flats plus a whole bunch of other areas. And because that builder with whom I had a tripartite agreement has now given it to a new builder, the new builder refuses to recognize me. Now I'll show you the photographs which I placed on record where the construction is coming up and third-party rights are being created. So the owner of the land is being owner, and now let me just qualify by owner what I mean. There is the first respondent before your lordship is technically the owner of the land. I have a tripartite agreement with the owner where he recognizes me, he recognizes a builder who is not my learned friend's client because he's the successor, and the project is to continue. That allotment to me, so here you have a situation where the owner is being deprived of the land, deprived, and the current builder does not recognize him. Now, first and foremost, I want to show you 2 or 3 technical points. Just go to page 2. Just see how the question I ask myself is, this is ex facie deserving to be stayed because I never asked for this relief.
At the moment we'll state, High Court will not decide the matter.
Sorry?
High Court will not decide.
No, I am saying there are 2 things. I'll just show you my prayer because your lordship made a tentative observation. If there is some manner of protecting me, I don't want to stall the project. Just go to page 2, please. Please go to page 2. Now just see my 2 IAs. IA number 2 of 2026, your lordship has that about 10 lines from the foot of page 2.
Page 2, yes.
Yes, this is where the reliefs are set out. So I'm going to just show what my reliefs were. Petition under section 151 CPC, praying that in the circumstances stated in the affidavit filed in support of the petition, the High Court may be pleased to direct the parties herein to maintain status quo in respect of the subject project, Wasabi Lake City, situated at survey number so-and-so, pending the hearing and disposal of the case. That's one application. My second application was, again under 151, High Court may be pleased to direct respondent number 3, which is my learned friend appears for respondent number 3, not to make any conveyance and transfers of the project area in respect of the Wasabi Lake City situated at so-and-so, and the details are given. Now, on these two interim applications in my favor, what is the court saying? Issue notice to the respondents, I can have no complaint of that. There shall be an interim stay of all further proceedings pursuant to the order of the Telangana Real Estate Appellate Tribunal, number so-and-so, till 21st April 2026. So, my complaints are there before that thing. I never asked for this particular prayer or relief at all. So far, instead of granting the relief which I had asked for, and considering the relief in whichever manner, he grants the relief which the other side is seeking. Namely, that the complaint should not proceed before the Telangana Regulatory Real Estate Appellate Appellate Tribunal. Now, this, so this is one huge, my lords, non-application of mine, that there should be an injunction of this type. There may not be any interim injunction, but it can't be that something which is contrary to what to my interest is passed in my own order, in my own application. Now, this is one. Now, number two, please just see what is happening over here. Then I'll give you the background of the case, why we are requesting status quo. Just please take up IA 148586. 148586. This is the one where we have placed these recent orders. Now, this is a large tract of land.
Page.
Yeah, you may just go, if you have the IA, the orders are first place, and then please go to page 51 onwards. Now, my whole case is...
Yes.
Yes, now your lordships have these projects and flats are coming up. So I have, because I am the owner of the owner, I've told your lordships, I was not the registered owner.
Got it from the owner.
But I have an interest. Yes, there's a tripartite agreement, etc., which I, if necessary, I'll place on record. So these flats, etc., are being put up, and he is selling these particular units to third parties. So I am saying that, look, insofar as my interest is concerned, which I have claimed, because I'm entitled to a certain amount in terms of built-up area, that has to be preserved and protected. Because I am he came into the picture only because of me. Now, my agreement originally was with a particular developer, and that your lordship will just see from the course title.
No, that you would be entitled to 21 apartments.
Plus a certain computational area.
That in Tower 1, 2, 3, 4, which apartment?
Yes, so Manoj, I'll just indicate to you there are 21 flats and an enhanced area of 3,57,200 square feet super built up area. This is what I have, and I've given the details, etc. This is my eventual entitlement and my claim. Now, this person says that you have no privity with me. I have stepped in, I don't recognize you at all. Which is why I'm agitating before HERA, before the authority. Now, so the first question I ask myself is, how does an order like this come to be passed in my application? It may be passed in his application, can't be passed in my application, and someone has to consider it. So I appreciate what your lordship is saying, that maybe there ought to be an application of mine on the part of the High Court, no problem. But then your lordships will, whatever.
Proposed to do during the...
He has already got those flats. In his writ petition, there is a finding he has got those flats. He has disposed of those flats.
I've got 3,57,000.
I'll hand over the order to your lordship. Please see, High Court, while dismissing his writ petition, has said that this writ petition is not maintainable because with super built up area of 11,130 and 16,000 under the two agreements, as discussed above, this is at page 19, my lords, of the order, stood extinguished. Page 19, internal page 19.
27 January 26.
He had filed a writ with the same prayer.
Who's there?
Same prayer. Now please see this, my lords. This is nothing but a ruse to get over what has been denied, and this was upheld by your lordship. Please see 19, 21. Yes, 19, my lords, para 10 at page. It is thus clear the finding.
There's an appeal pending against this.
So now disclose this. Yes,
yes,
see para 10
this is a different
page 18. It is thus clear from the above transactions, we read document number so and so, that whatever rights the petitioner had, which was him, under the agreements of sale cum GPA dated 6, stood extinguished upon the petitioner receiving flats with super built up area of 11,130 and 16,615 under the two above agreements. As discussed above, not only that the petitioner received the flats in lieu of agreements of sale and investment, but has also acknowledged cancellation of development agreement, supplementary development agreement, and further subsequent development agreements made in favor of respondent 5. In view of the same, the court does not have any hesitation to hold that the petitioner has no subsisting interest over the property and locus standi to file this writ petition. Therefore, it is dismissed. And now your lordships are being told, my lords, that they have a subsisting interest and there should be a stay because all the other remaining property is with me and I shouldn't be allowed. I have invested money.
This order was not brought to our notice.
No, just please see
And
pages
this
6
was-
and 7.
This was filed here.
Please just see pages 6 and 7 of the, so the cost title. So I'll just explain the situation. Please just see pages 6 and 7. Now the tripartite, so for respondent number 1
7
of the paper book, SLP paper book.
yes.
SLP paper book, P. Raja Rao is what I would describe as my vendor or the original owner. Let's call him as the original owner. He's respondent number 1. I have a tripartite agreement and the other party with whom I have an agreement, etc., who's the previous developer is respondent number 2, Messrs. Sri Sai Ram Projects Limited. Your lordship has that. So that is my foundational document on the basis of which I have to get additional area on the basis of what is constructed. Now the person who's the current developer is respondent number 3, who's Vasavi Realtors LLP. Now because Vasavi Realtors LLP is not recognizing my entitlement, he has stepped into the shoe.
It is, but this order is between the same party.
Yes.
Yeah, no, this is in another context. my lord.
It can be.
Just see the order.
Did you disclose this in the SLP?
This is a separate my lord's proceeding.
Did you disclose it in this SLP?
I don't know, my lord, whether
With
this is-
respect to the same land, same flat, everything is.
No, this is on building permissions.
No, maybe building
Maybe,
permission,
but
but
with
this
respect to
has
same
findings. This has findings that you have been given the apartments.
No, but those are different my lord's apartments.
No,
Please.
this should have been disclosed.
Is it?
We are not inclined to interfere.
Grateful, my lord.
Very well, grateful.
Wait, please, my lord. On the last date, my lord has asked me to prepare this like small chart with respect to the amount of interest, my lord. So it is a small chart with respect to the amount of interest if calculated as per the section
Already
170.
enhanced.
No, if my lord may please see the para number 6 of the impugned order. Para number 8, my lordship, last line is from the date of filing of the appeal. It should be from the date of realization. So I have also mentioned the small chart as to, my lord.
How much interest have been given?
The interest was 6%, my lord, but from the date of filing of the appeal, not from the date of filing of the original petition. And as per the interest act, section 3 and section 177 of the Act, my lord.
Limited to question, limited of interest.
And my lord, other aspects are also there, my lord.
No other aspects. No other
My lord, because my lord, there are
No, Mr.
other
Costa, no other aspect.
development.
Limited on to the question of issue note.
Please, ma'am.
This is 61.
Yes, ma'am. This is a bail application, regular bail application. My lord, in
Number 61.1,
61.1.
it's a press case, no notice has been issued.
my lord, in 3 of other matters, my lord, in
Notice
the,
been issued.
yes, ma'am.
What is the stage of the trial?
It is going on prosecution evidence. I think 3 or 4 witnesses have been examined.
Please, ma'am.
3 or 4 have been examined.
Yes, my lord. And my lord, my role in 61 is that I was the attesting witness to that agreement only. I was not named in the FIR as well as in the charge sheet. So there is no culpability shown on my part, my lord.
Correct? Yeah.
Okay, case.
Spurious liquor.
On advance.
Please, my lords, I appear on advance notice. I'd be filing a counter if my lords would give me time.
Please file your counter
Please, my lords.
within 2 weeks. Rejoinder by 28th July, release 27th July.
Please, my lord.
Obliged.
61.1.
Same or
62 is also same, my lord.
62 also same?
Yes, ma'am.
Take it.
Poisonous liquor.
2.1, had sought time to file additional document. I filed it, notice is not issued.
We are now issuing notice.
In earlier SLP, I could not file.
Then piecemeal. Why do you file anticipatory bail in complaint cases if you are appearing before the court? You invite trouble for yourself.
Lordship,
This is a complaint case, right?
yes,
So you are appearing before the court.
High Court direction that if you are not the direction to the.
Why did you approach the High Court in the first place? Where is the apprehension of arrest?
Lordship.
Yes, fine. Anyone from state of Bihar?
I appear for the state. I appear on advance service, Millets.
You are appearing. We'll keep it on Monday, madam. Right?
Well, very well, Millets.
Monday.
Could you please be permitted to give my physical appeal?
Yes, yes. Monday. We'll dispose it of.
Grateful, Millets.
I don't have much to say because already
Lordships have
similar
dismissed
matter has
the
been
matter.
dismissed.
Against the same impugned order, Lordships have dismissed.
Dismissed.
Yes, yes.
Very good. Dismissed.
Grateful.
Only prayer, my lords, if some concession may be given and he may be permitted to surrender and
15 days
suffice.
as prayed.
Grateful, my lords.
Grateful.
Millard, this is an inappropriate use of the contempt jurisdiction, Millard. Millard, the sanctioning authority has been hauled up in contempt.
Please, I am for the respondent, Millard.
No, just 1 minute. Mr. Gupta, is not an intra-court appeal maintainable against this order under the Kerala High Court rules?
Millard,
Moreover, it is an interlocutory order, Millard. Court has only said that you
I can
passed
check
the
that.
order.
Because
I can check.
Just-
Keep it
just-
on Monday, Millard.
check up.
The operative part of the order, if you are.
Kapur People's Cooperative Bank Limited versus Chunilal Nando.
Lordship.
Judgment of Justice BP Singh and Justice Ravindran
Very
clearly says that if you are not punished for contempt,
Lordship.
then if any order prejudices your interest, you must go for an intra-court appeal if the High Court rules permit it.
Lordship, I'll check up.
Just check it up.
Yes.
Because why should we entertain?
No, of course not.
No,
Millard. If I
because-
have another remedy,
Because one thing, this is an interlocutory order as
this
you
is
learned.
an interlocutory order.
And the court has
It was
said
staged
before
prior to the
18th, you
punishment.
let.
Correct.
Stage prior to the punishment, you have been asked to show cause.
Yes.
Why you should
And-
not be
and
punished.
we-
Millard,
personally present.
Millard, may I only point out that the
Millard,
court
this-
has directed
No, no.
them to
that-
pass a fresh order.
No, no.
That order, let them pass. Kindly see page number 66,
Millard,
Millard.
this is-
Para 23, Millard. Since this court already found
There
that.
is a problem. There is a problem. Pass a fresh order
Yes,
may not be possible within contempt jurisdiction.
because that has been,
Punishment.
that has been set
If you
aside.
go strictly by contempt of courts act, it is either imprisonment or fine.
Listen,
But since there is no express provision for execution of orders passed in writ,
yes,
we treat it as an execution proceeding and get it done.
But Millard, here is an authority which is supposed to take a decision. He has been told that he didn't apply his mind in the first instance. So we took a decision again and repeatedly, Millard, contempt petition.
Can you come back?
Yes, yes.
Can you come back in the second call?
Yes, I can. I'll check.
Because you are required to appear on 18th.
Yeah, that's right.
So therefore, if we keep it on 18th, it will be number 60 once again.
I see. All right, Millard, I'll be here. We'll find.
Second call, sir.
Millard. I'm shooting. Battery bail in item 1 and 1.1. Honored.
Acha, you are for the state?
I am for respondent number 2.
You are for the state. He died 4 months after the incident.
Please one.
Correct? 302 has been added. We are not on it. But he was granted bail earlier. So why should it not be continued?
My lord,
You tell us now, complainant.
my lord,
He got, when it was 307, he surrendered.
firstly, I would like to submit that the petitioners have tried to mislead the court, that they have tried to make this a case of a simple knee injury, which is not the case.
We are not on that, sir. That stage is crossed now. 307 was the original provision under which the FIR was registered. He surrendered. Thereafter, he got bail.
Right.
After he got bail, the victim died.
Right, sir.
He died of septicemia.
Yes.
Now, the question would be, when 302 is added, in the trial, it has to be shown
Right.
that this death arising out of septicemia is directly related to the injuries that he suffered.
That is for the trial.
They are now putting up a case that he had very high diabetes. Therefore, that is why he died.
Diabetes was.
Now this has to be gone into in the trial.
Yes.
So he has suffered incarceration earlier. Charge sheet has been filed. What will be the purpose in taking him into custody now?
The proper course, my lord, would have been to approach the trial court for regular bail.
Allow.
Obliged, man.
He based them for reasons to follow allowed.
My lord may just order for trial to be expedited.
We'll consider.
Okay. Obliged.
7.
Yes, Phyllis.
Manoj,
Just to recapitulate for my own benefit.
You were not there in the first call.
I apologize, Manoj. I was
Yes.
Yes, Phyllis.
So this is NDPS.
Yes.
From a swift desire.
Yes.
2.6 kg of opium recovered based on disclosure of A8. You are A7.
Yes, Phyllis.
You have been arraigned as an accused. Charge sheet filed. Role of P, that of financer.
Yes.
No minutes. Now, no grounds of arrest were supplied to me at the time of arrest. No, there is no diary entry in the local police station. No transit remand was secured from the local magistrate. And all these 3 grounds have not been traversed by the state in their counter affidavit also. Now, allegation against me.
No,
is,
did you raise these grounds before the High Court?
yes, Millets. But it
Where-
is not
where is
adverted to.
Let us see, where have you raised it?
Yes, Millets.
No grounds of arrest, no transit remand.
Yes, Millets.
What was the third point?
No DD entry in the local police station, diary entry. Millets.
No diary entry.
Yes, Millets. Before the High Court.
Where have you raised these points?
Yes, Millets. Petition डाला है. Have you filed the petition?
Because I believe it's page 93, my lords, their application. It's a
Page
annexure
93.
P10 is their application. P9 is the application before the.
99.
It starts from 79, but 93, the
93,
relevant
where
government is
where
there.
In 93? Was produced
There's
before
the
court
numerical number 14.
the remain-
No, my lords, this right accrues from a judgment which was pronounced in November, my lords. A remand application would show that orally it was communicated.
This
Isn't
was
it?
his judgment.
Yes, my lord, this is November 2025. So before that, the administrative guidelines were, it should be effectively, the remand application would reflect that it was orally.
Anyway, now has he been given the grounds of arrest?
Yes, my lord, the remand, yes, the charge sheet has been filed. Your lordship have posed specific 7 queries on the last day.
Yes.
We filed our count.
His charge sheet on 7th February, it has been filed.
Yes, now it's for framing of charges. 6th June is the next date, my lords. 26 prosecution witnesses are there. Trial is yet to commence. There are certain co-accused which are yet
How
to
do you
be.
connect him with the crime?
No, my lords,
Show us
there's a.
from the charge sheet.
Please,
How do you connect?
I'll just summarize, my lords. So the allegation against him is in the para 10 on the counter that he has, through Hawala transactions, some money has flowed around 10 lakh rupees, which was used to procure this 2.7 kgs of opium. So the relevant part is the recovery of a 1 rupee note of a specific serial number, which was used as a token to sort of authenticate these Hawala transactions, which has been recovered from one of the co-accused, my lords. So now his business front was being used to facilitate all these Hawala transactions. So now it's not a simply case of the disclosure statement he's been arraigned, subsequently a note, my lords, which is a note which used to be in print in 1994, my lords. It's a rarity. Now that has been recovered. That's annexure R2. That's there.
The,
Or with the,
well, the note has not been recovered post the disclosure. That has been.
so my lords, the rigors of
Well,
37
may your lordship please have page 113 minutes. Please have page 113. Whether this transaction of 10 lakhs is part of the OPM seized or not, this is clear in 113, the disclosure statement of the co-accused. Now, may have 18th line from the top. The person who has supplied this is the disclosure statement of the same person. Now it says, whereupon I went to a person in Ucha Ghasi building in Chandni Chowk, Delhi at the location told by the Jitin and sent 5,25,000 rupees to Jitin, resident of Nepal. After 3 days of sending the money, Jitin called me on WhatsApp and told me to take 3 kg of opium. So the money was supplied before the supply of opium. So this 10 lakh transaction they are showing is after the seizure. And bottom below those lines there, he has also mentioned this 10 lakh for further procurement. So the seized amount was seized opium was not part of the 10 lakh transaction. It was prior to that. Now, the second point is,
yes,
for the 10 lakh transaction, first of all, what is the material? Only except disclosure, there is no material which has been linked to me. Who has paid me 10 lakhs rupees to pay to further accused? There is no material. I was not even named anywhere before the co-accused disclosure of Rajesh, son of Fagu, whose disclosure was recorded after my arrest, 1 day after my arrest. There is no material in the entire charge sheet which has named me before my arrest. There is no section 42 compliance also. So, this is why this is not only grounds of arrest. Grounds of arrest had clearly not been supplied. And there is no 42 section also,
Charge sheet, now you are aware of all grounds.
the only role is him to.
So this is
But
only
this is
financial
the support
transaction
of
they are saying,
moving money.
and the money has already been paid as per the co-accused statement also. And there is no criminal antecedent,
That mafias, they work in this manner. So.
Please appreciate, this is not the transaction,
sorry, we are not in a position to form an impression at this stage that you
but the judgment, on the ground of arrest is clearly says that, the grounds of arrest has to be, Priya and Doria says that there should be a judicial. The liberty may be given, to approach the Honorable High Court.
1 year from the date of commencement of trial.
No, it will be.
What? No, my lord. The charge is yet to be framed.
Grateful.
Don't delay the framing of the charge.
No, I don't want to delay that, but please hear me on.
Next matter.
The grounds of arrest has not been supplied. There is no intimation of the grounds of arrest.
Matter 9. Who is in 9?
There is. Please hear me. He's an honest gentleman. The case of this.
Honest. Everyone is honest.
The disturbing facts are there.
You have been entangled wrongly.
They may show one material, except the disclosure, they may show one material in which I am there. The note has been.
Thank you very much. Very well argued. Thank you. Next matter. Who is for the state of OP?
May I please, just one line, There is a disclosure statement.
You have wonderfully argued.
No.
Thank you very much.
No, I would appreciate if I get an order.
You will appreciate.
Not
in this.
Please,
in a better case, you will get an order.
It is a good case. If I am not convincing your lordship, I am failing in my duty.
Yeah, we have to form an impression under 37 that you have not committed a crime. It's our impression. You have tried your best, sir. But we are not satisfied. Can we not record our satisfaction that we are not satisfied?
All I am praying, what is that one material apart?
Your persuasive skills in some better.
It is a good case. I am failing in my duty. This is what I can submit.
It's a good case, but we require a better case. It's a good case, but we require a better case for you to succeed. Sorry, sir. Please.
Just one thing.
Yes, madam.
Apart from the disclosure, what is the material?
Next. Please.
The note has been recovered prior to my arrest.
Yes. Please allow her to submit. Next matter.
My lord, the issue in this matter pertains to the regularization of the service as well as
He has
the
worked
payment.
for how many years?
My lord,
30 years, my lord.
30.
30.
my lord,
And now I have already retired.
he has retired,
Please
my
rest.
lord.
Permit him to rest in peace.
Yes.
Rest in peace means that don't drag him to Supreme Court.
But my lords, can you only submit?
No.
My lords,
Only submit what?
only submit one thing, my lords. What I just want to bring in the notice of this court, that first the writ court and in the special appeal, it was observed that his appointment was incorrect. My lords,
Unlegal appointment. You permitted it for 30 years, madam. 30
lords,
years.
my lords, 30 years on the other post, the dispute is with respect to the office.
Very sorry.
Because of the interim order of the Honorable High Court that he continued, my lords. It is not
So it means the state was sleeping. The state could have filed an application for early hearing. The state could have got the matter decided. Please, madam, 30 years retired employee, why you are harassing him?
I only request for the
Now you also please, your case is over. Next case, please.
condonation of delay, my lords. Condonation of delay.
Yes, condonation of delay, granted.
Maybe. My lord, there are several points in this case. Rarely you come across a case with several points. Let me now explain, my lord, one by one. My lord, your lordship may note before I go proceed, my lord. My lord, the security is 8.51 crores. First installment is also 8.51, and so is the second.
Defaulted on the third installment?
Now, third, for the third, my lord, it was my case that the land was submerged, and therefore actually it was not due, and there should have been a modification of the term, is my case.
No, where is that provision in the contract?
Yeah.
That if we are not in a position to mine for
So,
weather conditions or any other.
so my lord, I applied as vis major, but leave that for the time being. I am now going a little forward. I am saying, my lord, even if you take the third installment as due, though I have identical cases which I cited in the High Court of a division bench of the same ground in the same belt, my lord, that this was submerged, the High Court, my lord, sent it back and said you can't do this without hearing, etc. And this is too harsh, my lord, to doing it. The division bench says that they are not binding precedents. That is completely wrong, my lord. It can't be on the same facts, on the same law, on the same lease. Now, my lord, just note one by one. What I said was, please take away my security. Please take it away, my lord. According to me, it is not due. Take away my security in lieu of the third installment. If that is so, please take it away. But it can't be that you take that away and then again say third will also be due.
It is provided, then, sorry, if it is provided, you say it can't be that after.
My lord, you have to give me a hearing. I got no hearing anywhere.
No, because you did not get a hearing.
Yeah.
Correct? But the High Court has held that even if the
It was an empty formality.
there would be no change.
Your Lord, that is completely wrong. My lord, your lordship judgments, judgments say that unless prejudice, this only case of
Judgment is that 2004, volume 4, 281.
Yes.
Escort farms, that if on a remand, there is going to be no change. in
undoubtedly,
outcome
undoubtedly.
Unless you can show substantial.
I am now going to show.
But sir, Mr. Rodgi, 18F page 18F, clause 58, and your lease date 111.
Yes.
Both courses are open to them. They can forfeit the security. They can also go for
Now,
recovery of the third installment as an area.
so, my lord, should I have not got an opportunity of hearing that please take away one but not the second?
Why? Where is the scope? Where is the scope for?
Just see 18E, my lord. 18E. E. My lord referred to one provision.
Yes.
See 18E, my lord.
18E. Yes.
At the foot of the page, general provision.
Yes.
The lease may be terminated for a breach of rules, covenants, condition. If the lessee breaches any rule of the UP mineral rules or any covenant of the lease, the state government may terminate the lease and forfeit the security in whole or in part. I am entitled to say, please do take one, not the other. And my lord, I wanted to show you one more term of the lease, which says you can't do it without giving me a hearing. The High Court says hearing is a must but not necessary. Just turn to 138 now. My lord, 138. And I'll show you, my lord, the other judgments of the same High Court on the same point. My lord, 138, the first subparagraph. Further, clause 1 of subsection 2 of part 2 of the lease states, if the lessee violates so and so, the state government, which I am reading, my lord, wholly or in part, provided that before cancellation, lessee will be given an opportunity of hearing. Number one. Number two, now see, my lord, how the state government has done in a statutory revision in regard to the same point. My lord will turn to page 185. 185. I will show you, my lord, this and other orders of the High Court on account of submergence. This is, my lord, a case of one Jimmy Singh, my lord, at 185. Jimmy Singh. My lord will see 186, middle of the page, my lord. When the petitioner attempted to commence mining operations after the monsoon, same period as mine, it was discovered that the area was submerged and the Cji-Sc made an application seeking termination or surrender of the lease. The application is not considered by the DM. He issued a notice, cancelled the lease, forfeited, everything was done. Now, my lord, you will find the state government says that, my lord, after hearing everybody, turn to 189, my lord.
189.
Last portion. First subpara. Upon examination of the counter submitted by DM, it is apparent petitioner did not pay the third installment and the fourth. Exactly like me. On account of which the DM cancelled the 59. However, the supervisory stated that after the monsoon, a binding copy could not be carried out. Area was submerged. Counter report contains no mention of evidence that the petitioner carried out any mining after 30th September. Further, the allegation of this blacklisting is separate. In view of the above, that portion of the order passed by the DM, specifically those related to forfeiture of the deposit security and entry supervised in the blacklist set aside, remaining order will stand. He will adjust the security and recover against Millard the third installment. Number one. Now, Millard, your lordships come back to identical High Court orders on this issue, which are, Millard, set out. Millard, your lordship will be pleased to turn to page 20. Millard, kindly turn to page 20. 20.
Please again. You should not have provided Mr. Rodgi with High Court Division Bench orders when there is a Supreme Court order on the same point.
Oh, I see, Lord. Then it is my fault, Lord. I must acknowledge that. I must acknowledge that, Lord. Mr. Lordship, give me. I am very grateful, Lord, for your Lordship's indulgence.
We were just trying to understand what
the
is.
No, Lord, if your Lordship's order is there, then I don't need anything else. They're directly on point. Direct. Milord, my apologies, Milord. My apologies. Directly.
What is the proceeding that has now been taken against you?
So now he says, Milord.
Have they initiated any proceeding?
Yes. So the notice has been issued that they will recover, Milord, by areas of land revenue after adjusting the security.
Stay of the notice dated.
The Lordship says stay of for coercive proceedings is good enough, Milord.
No, that notice that has been issued to you.
14 January.
Milord, 14th January.
14 January 26.
No, 19. It started in 19 and these proceedings went on, Milord. My Lord may say no coercive.
No coercive. Yeah. Till the next date of hearing.
And I'm grateful, Milord, for your Lordship's indulgence in giving me the judgment. I'm very grateful. Kindly keep a note of this.
Without
apologies for out of turn.
Without that, we were going to dismiss. Without that, judge.
It's a lucky day, my lord, for this client at least.
Yes.
It is the amount is slightly of a commercial millets. He has no criminal antecedent. The only liberty which I am seeking millets that post framing of charges he may be allowed.
At this stage, कर दीजिए madam.
Let's note से related कोई भी कुछ
yes,
नहीं है.
At this stage.
Millets.
Now you take advantage of at this stage.
Post framing of charges millets. Oblige millets.
Yes, next matter.
Lord, this is a case where my husband...
We should make it an unlucky day now.
I don't know, Lord, it may well be. There is one point, my Lord, which is very clear, which is now pending a larger bench of this court. And the point is, can you, in respect of a 138, also file a criminal case? So that you have two cases, 138 and 420. This issue, my Lord, has been raised before this court and referred to a larger bench. This is the judgment, my Lord, of your Lordship. That is one. That is one point. Second now, yes, this is one point. Where is your Lordship will find? Yes. My Lord, kindly see page 2 first, my Lord. Just to show you the facts, my Lord. Page 2, paragraph 4. Paragraph 4 will show you, my Lord, that about 138. Then, my Lord, just 4 lines above paragraph 5. Therefore, only the respondent number 5 registered a case under 120, etc., etc. Challan was filed. Then, my Lord, matter went on in different courts. And then, your Lordship will find the ultimately at, my Lord, the second last page of this judgment. Second last page. Second last page, my Lord, towards the bottom.
Yes.
Last 5 lines, my Lord, above item 1. In our view, the aforesaid judgment cited by the respective parties are conflicting. However, to avoid confusion, we deem it appropriate to refer the question to larger bench, whether this case or this case, which is now clear from the last page, whether on the same similar facts of allegations of fact that the accused can be tried for an offence under the NI Act, which is special enactment, and also for offences under the IPC Act. So the same thing is happening here. Now something, my lord, very, very peculiar in my case.
The offence has not been decided.
No. Now, my lord, something very peculiar in my case. I am not relying only on this. My lord, my husband had some dealings, my lord, of a loan from this party. No problem. It was going on, 36% interest, he paid, etc. In the course of that, my lord, some documents, my lord, were blank signed by me, that I am the wife. I had no relationship. Some blank documents were signed in terms of an MOU, an agreement to sell of some property which I have, and, my lord, these checks, etc. They have been utilized, my lord, to create this, my lord, 50 lakhs worth of this, my lord, the check. Well, I have nothing to do with him. I don't owe him anything. My husband had some dealings, etc. Now, my lord, I lodged an FIR that they are all full documents. They are blank documents. My FIR is registered, my lord. Charge sheet is, he was arrested. Charge sheet has been filed. Trial is pending. In that, my lord, FSL report has been called for and a status report has been called for. And the police are on record to say that, my lord, those documents are, my lord, forged and blank. There is a report of 75 pages to that effect. Number two, insofar as, my lord, his case is concerned, that once you say there is a closure, that in this FIR there is a closure by saying if you have forged this, then you can't have a case. It is in the light of these facts, my lord, I say that the second case has to be quashed, my lord. There are two documents I wanted.
Date of that second case?
My lord, my case?
Yes, both these.
So my case, my lord, charge sheet filed against him, arrested for all these fake documents, and there is, my lord, a CFSL report on that regard by the government, a big thick report. Insofar as his FIR, which I, my lordship, asked, there is a closure filed, my lord. There is a closure filed, which is, my lord, at page 181. And the closure is filed by saying that since you have, my lord, filed an FIR based on false and fabricated pages, you can't have an FIR, and in my FIR you will face the music. In the light of all this,
The report is there, but signatures are not disputed.
I'm saying blank. I'm saying blank, my lord.
Court has arrived at a conclusion that the signature.
High Court is wrong. I'm saying, my lord, it is signed.
This is 2008 Negotiable Instrument Act case.
Yeah.
You are dragging it since 2008.
Because it is, my lord, a false.
Some pretext or the other, you are not permitting the case.
It's a false case. I owe nothing to him.
This is what, see, kindly see para 44 on.
I know, but now let's see the report. Let's see the report.
This can't be decided in a 482.
Sorry?
It can't be decided.
Look at,
in 482.
Lord, look at the facts, my lord. It's not a simple, look at the facts. This lady of an advanced age who owes nothing to him in terms of a debt.
Just can't be decided. No, it can't be decided.
My lord, may I say this? At least on the question of reference, my lord, a reference.
Sir, you know us. I mean, we can go to any
All right,
extent
yes.
if there is something in the case.
My lord,
No,
Sorry.
My lord, if I may say.
I can deposit the amount, my lord. If this is so, I will ask and deposit the amount
Sorry, sir.
and then face it.
Yes, next.
Now, your lordship will recollect, my lord, on the last occasion,
Yes, Mr. Solicitor.
lordships. Now, your lordship will recollect on the last day, it fell from my lords. Either you come back or otherwise warrant of arrest was issued has been wrongly cancelled by the High Court, my lords. He has till date not yet come back, my lords. And he has been just sending some mails on some or the other pretext and he has not been coming, my lord. Now, what a court will have an option, my lord, against a person who has not been appearing and the agency, my lord, who had to investigate, my lord, and he is not coming, my lord. And it's not that he had no knowledge. He said that I had no knowledge, but then he himself had sent a mail seeking adjournment. Therefore, it is not a case in which in this situation, High Court ought to have exercised power under section 482 to quash the warrant, my lords. It's only in the compelling circumstances that the warrant of arrest had to be issued. And that was issued, my lords. And in the trial court, he filed his wakalatnama, my lords. Now, I fail to understand what a wakalatnama will do in a trial court unless you appear in the trial court. You had to appear on some or the other mode, but always he has some pretext or other refused to come and join. And on this ground only adjournment was sought on the last day, my lord, when the matter was heard by your lordships, my lord, your lordship will recollect. And notice was not issued as yet that he will appear.
Without notice, sir, is there?
That.
Now let me show you. Let me show you. My lord,
Mr. Lodgi, after the court passed the order on 10th February 23, you went abroad?
Yes,
I was always
abroad. I am a UK citizen.
I'm a citizen of UK.
I am a citizen of UK. I live there. Now something not peculiar, which I must tell your lordship now, which is not stating. So they find
very well. We'll accept that you were always in UK. Now, when your presence is required, and you will not come.
So this is what I am showing now. Have a look at this. He should have shown you this. Give a copy. Now, my lord, they have filed a complaint against me. They already filed a complaint, which was filed on, please note, my lord, it was filed on 10/2/26. This order is of 11th May, 2 days back.
Yes.
Now, my lord, under the law, for the first time, an accused is required to be heard at a pre-cognizant stage, your lordship know in 223. Notice under 223 has not been issued to the proposed accused, which is my client. The court has directed with an order of one document complaint is illegible, legible copy is yet to be filed. Next page. Next page. Notice has not yet been issued. Now, my lord, your lordship sees middle of page 2. Learned SPP submits that the department proposes to file an application for issuance of NBW against A14, my client, and therefore 1 week's time be granted. That application will be filed, it will be considered. So they will file, it will be considered. Now, my lord, kindly come to the last page. Last page. As and when that application is filed regarding NBW, same will be considered. Now, next line. At this stage, Mr. Agarwal, Mr. Periwal, appears for proposed A14, my client, files his wakalatnama, he requests for copies, etc., matter is adjourned. Now, under 223, I have to be heard. I am present before the court. They are saying, I will file a further, without NBW. What NBW will you file when I am before the court? And I am entitled to appear without through counsel at the stage of 223. If the judge requires in a particular case, he will do whatever he has to do. What remains in this SLP today?
Court said that.
And one more thing. I was summoned as a witness. In 2 months, I have become an accused. I have been summoned as a witness, Milord, in the impugned judgment. This is not a case, Milord, where this non-bailable warrant will survive.
So he says that.
And suppose. Cognizance is refused. Matter ends with the question of any warrant. And you say we will file warrants application before the judge. He says you file, then I will see. Number one. Now we'll just turn one more minute.
If he is not appearing through his counsel, his
that is
counsel remains absent. Urge the magistrate to pass appropriate order.
No. Even before that, my lords, the question here is that we are in the SLP against the Honorable High Court quashing the order, my lords,
Yes.
of warrant, my lord, quashing the warrant, my lord.
I'm
And
present. What is the
not-
purpose of?
you know, your lordship, is a question of his presence will only be required when in the present proceeding, my lord. But then so far as the investigation is concerned, my lord, if your lordship will see,
There is no investigation. Nothing. Complaint has been filed.
the impugned order, your lordship may kindly see the impugned order. My lord, under the provisions of section 44 of the PMLA Act, my lord, it's not that it ends, my lord. It's continuing qua him, my lords. Now, if your lordship will see, kindly come to page 2, my lords, of the impugned order.
Yes.
It says that this High Court may please to set aside the order dated 9/6/23 in miscellaneous, thereby quashing non-bailable warrants. He remained absconding, my lord. He did not appear. And warrants issued against the petitioner by order dated 10/23 miscellaneous, being bad in law as all proceeding emanating therefrom. Now, my lord, he cannot be allowed to take advantage of his own wrong, my lords. He has not been appearing before the court. Then he went to the High Court seeking quashing of the warrant, my lord. And the warrant has wrongly been cancelled, my lord, in spite of the fact. Now, if, and further, my lord will kindly see.
You have only prayed before the magistrate.
That you will file if necessary.
No, my lord, that is, my lord, that is,
My
my lord, that is with respect to the present. Now, after the,
Proposes to file an application.
your lordships, after filing the complaint, my lord. But then this is even prior to this, my lord. Now, your lordship is testing in this SLP whether this order which has been quashed, my lord, is correct or not, my lord. Now, that your lordship will see, because
Subsequent development, we need not. We'll keep the point open.
No,
We have
one
the
more
order
fact.
dated 11th May 2026, passed by the special judge within brackets so and so, so and so, so and so. We see no reason to entertain this special leave petition. The same stands disposed of, keeping all questions of law open. We also leave it open to the Enforcement Directorate to make appropriate application before the special judge in case the respondent,
Which will be decided on the own
needs to
merits.
evade the process of law.
Yes. That's not.
and it may not be treated as a precedent, my lords.
We have kept all points open.
But then still, my lord, they will come back and say that High Court, Supreme Court has declined to
We kept
interfere.
all points
So,
open
my lord,
in view of
only,
the, we have said in view of the subsequent order.
Lord, but then your lordship may also say in peculiar
Non-merit.
circumstances.
Next. 53.
My lord, Shashidri Naidu sir was here, just suddenly have to move the another court. So short date may be granted,
No
Monday
court
by
is-
Monday.
No court is functional.
In the court number 7.
Court number?
7.
Not today.
My lord, if it is the end of board,
It's already 1:15.
so my lord,
Monday.
Monday. Grateful, my lord.
Very good.
You're okay?
Absolutely.
You left early. We heard that you injured yourself.
No, brother, it was just the hamstring, but otherwise it's fine. Not much of a problem.
Okay, Monday.
Grateful.
Grateful, my lord.
Last hour,
I took out, my lord.
65. Oh, it's
Yes.
Mr. Gupta.
Yes, my lord, we've taken it out, my lord. Your lordship mentioned the Midnapur judgment.
Ah.
That says that
Roman 5 of a particular paragraph.
paragraph 11. Paragraph 11, Roman 5, my lord, I'm just placing.
Yes.
I'm just reading. If the High Court, for whatever reason, decides an issue or makes any direction relating to the merits of the dispute in a contempt proceedings, the aggrieved person is not without a remedy. Such an order is open to challenge in an intra-court appeal if the order of the learned single judge and there was a provision of an intra-court appeal or by seeking special leave. Now, 19, the judgment further says, my lord, that no order other than an order of punishment would amount to an appealable order under section 19 of the Contempt Act.
Correct. Correct.
And my lord, this has been followed now, my lord,
By a 3-judge bench of
by a
Justice
3-judge bench,
Chandrachud.
Justice Chandrachud. No, Ajay
But
Kumar.
now here you are prior to the punishment stage.
Yes.
If you are punished, then of course, in
Section
terms of
19 order.
Dane Taneja,
Yes.
Baradakanta Mishra versus
Baradakanta Mishra.
G.K. Mishra, your remedy will be under 19.
Right. But at this
But
stage,
is
it is
the
not.
only judgment which says,
Yes.
and we have been following it also in the High Court,
Lordship.
that you have not been punished and the intra-court appeal is available, you file it.
No, intra-court is not available because, my lord,
Why it is not available?
because section 19 doesn't apply.
No, we are not asking you to file a 19. We are, let us make
All
an
right.
appeal.
Now, on that,
Let us
Milord,
appeal.
my lord, I have been instructed that there is a full bench judgment of the Kerala High Court.
No, we will not follow that full bench. How can a full bench judgment stand in our way?
No,
When Supreme Court has cleared the position,
No, it has.
how can Kerala High Court
It says
stand?
nothing about, my lord, interim orders, my lord.
Why not?
My lord,
Your right is being affected.
my lord, just,
Your right is being affected.
my lord,
If your right is affected today, let us say
my lord,
there
yes.
is a definite finding of contempt,
Lordship,
but the sentence part is deferred.
Lordship.
You are not punished for contempt.
Yes,
It's not come up against the order
my lord,
finding you guilty of contempt.
my lord,
Of course, you can do it before a division bench.
no, my lord,
Unless, of course, you can show Section 5 of the Kerala High Court Act.
Yes.
You have it?
Yes, my lord, I have it.
Whether it bars?
No, my lord, it only allows in the case of exercise of original jurisdiction.
So this is original jurisdiction.
No, the contempt will
Of
not.
course, contempt is of course original jurisdiction. I have held with Justice Khanna.
My lord, if your,
Contempt is original jurisdiction.
my lord, if your lordship,
Please see.
Sir,
the
just
judgment.
1 minute.
I have held it.
my lord, let me.
Held. Contempt is original jurisdiction.
All right, very well, it is. But if your lordship doesn't set aside, my lord, the full bench judgment, I cannot be heard.
We will grant you liberty.
All right, very well, my lord. But then 18th, my lord, your lordship will consider. 1 week's time may be given.
Having regard to the decision of this court in Midnapur People's Cooperative Bank versus Chunilal Nando, reported in so-and-so, as well as the decision.
Ajay Kumar Bhalla.
Naman,
Well, I'll give the
decision
citation
that
to your lordships.
with Justice Khanna, courtroom number 2, I don't remember the name.
My lord?
Didi, I'm talking to my law clerk. He will just find it out.
My lord, the Ajay Kumar Bhalla judgment, my lord, I have it here.
Acha.
That is of
approved
Justice
by the
Chandrachud.
other bench of this court in Ajay Kumar so-and-so. Give the citation.
Yes.
As well as the judgment of
Write it down, write it.
this court in so-and-so. We are of the considered opinion that the order dated 10th April 2026, impugned in this special leave petition, has been passed in the exercise of original jurisdiction. And since no punishment has yet been awarded to the petitioner, an inter-court appeal before the High Court would be maintainable. In such view of the matter, we decline to entertain this special leave petition. Same stands disposed of, granting liberty to the petitioner to pursue his remedy in a manner known to law. Since, however, the petitioner is required to appear before the learned single judge on 18th May 2026, we request the learned judge to give some breathing time to the petitioner to pursue remedy as noted above.
Your lordship has said that he has been asked to pass an order only. Even if his personal appearance is dispensed with,
requirement such time as the order is to the bench.
He has a right of appeal.
Yes, my lord.
He has a right of appeal.
In fact, my lord, earlier order, this your lordship had said that there was no requirement of 197 my lord, sanction.
Next, my lord.
May I appeal? Lord, here it is listed for suspension of sentence.
Which one item?
Lord, 57.1.
57.1.
Yes, my lord, leave was granted. In the other, there were 5-6 charge sheets. Everybody got exemption from surrender without being inside for even a day.
Yes, madam, can be granted.
I leave it to you, Lord.
No, we are leaving it to you.
Yes, others have been granted. No.
Very well. Suspension of sentence granted in view of the fact that other convicts have been granted similarly. Appeal is ready.
And now the
Records have
trial-
come.
Yes, my lord. All they were connected matters. The
Very
order,
well.
order is
Appeal
at
to be
page
listed in
270.
September.
All the appeals.
Appeals to be listed in September.
Yes, all the appeals, page 270.
Suspension of sentence application disposed of.
Allowed.
Allowed. You said dismissed.
We said dismissed, huh? Yes, dismissed.
No. Because
You are getting the benefit. How does it matter whether it is disposed of or allowed? You are suspending the sentence.
Yes, sir. I'm grateful. I'm grateful, disposed of, yes. I'm-
Lordship, in 58, I am seeking some accommodation.
You are seeking?
Seeking some time because
You want to file additional document?
not additional, he has filed reply. It is regarding to
So
the
rejoinder.
land which I'll file my rejoinder and
File
meanwhile
your
I have to-
rejoinder. Within 2 weeks, released after vacation.
Lordship.
After partial. Next, 59.
May it please, Manoj. The upshot of it is there's about.
You want to get finally heard now?
No.
On a Friday?
I actually think because my instructions are, we are exploring if there is some possibility of trying to settle the matter.
It's an interim order.
Initiated, no, but whichever way, because there's something to be said on the merits of it, but we are possibly embarking on that. So my suggestion, if your lordship can put it after the vacation sometime in July or August.
Hey, July.
Huh? I'm grateful.
July.
I am squarely covered by Lordship judgment in the Abrarali versus CISF, where this court has held that since headquarters of the CISF is located within the territorial jurisdiction of Delhi High Court, the Delhi High Court will have the jurisdiction to entertain the writ petition. My petition.
Just 1 minute. Resident Commandant, Malda. So you move which High Court?
Delhi High Court, Lordship. Delhi High Court. In fact,
so Delhi High Court has said that Delhi High Court has no jurisdiction.
because of cause of action. Lordship, in fact, the
But what about
statutory appeal was also preferred before DG.
headquarters in Delhi?
Malad, his formation's headquarters is in Jammu. He was based
It's
in
not in
West
Delhi.
Bengal. No, Malad. So the first impugned order is
Lordship, please
But
have.
I'll tell you the ground reality. What the problem is.
In similar facts and circumstances. Had come up in the judgment. Lordship, may please just have it. In fact,
There
clause
is one judgment of the Supreme Court.
lordships.
Chief of Army Staff was the respondent.
Please, Malad.
And Supreme Court has said that if Chief of Army Staff is the respondent, it can be filed anywhere in the country.
Malad, the High Court has gone on forum convenience. He is a resident of UP.
Right.
He was posted at West Bengal.
If we will have to find out whether the Director General of BSF had anything to do in the matter. Because I find that the order was passed by the commandant.
So, Malad,
Commandant is not a party.
yes, and
Commandant is not a party.
then Malad,
In the
statutory appeal
statutory petition
is
dismissed by the IG,
Yes.
you
he-
don't make the IG the party.
but was preferred to the Director General. Lordship may just have page 21. In fact, Lordship had page 21, para 4. In fact, Lordship had pointed out to me on the last date of hearing. That's after that notice was issued.
No. Did you prefer any petition to Director General?
Yes, we preferred that statute.
Which petition? I mean, under
Statute
this-
appeal under Rule 28 of the
Statutory
BSF
appeal
rules.
was preferred before the IG.
Before the Lordship may have
To the
page
IG,
para 4. And then that
is
was transferred to the IG.
For the
Mistake.
appropriate
The
authority.
authority was IG only.
Both are the appropriate authority under Rule 28. If it is after in the summary proceedings, then thereafter,
In this case, who was the authority?
Lordship both have the authority. Lordship may have Rule 28A. 28A BSF.
Page?
Lordship, that rule is
The rule says Inspector General, Malad, 28A. So it's
Yes,
not
under
DG.
the rules, his appellate authority is IG.
Yes, Malad. And IG is the command headquarter of the frontier formation that his formation falls under. So both Impugn Order 1 and Impugn Order 2, both are passed, Malads, not in Delhi.
Either Calcutta High Court or Jammu and Kashmir.
Lordship, we just have this judgment.
He lives in UP
Thoroughly
also.
judged, CISF Lordship. The similar issue, yes.
Which judgment?
Abrar Ali was a
That is filed at page 16 in the SLP. He has filed it. Or you've handed over something else.
it's the same thing.
There the headquarter was, we don't know the specific facts, my lords, where the impugned order was disposed of where. Para 3 says that the headquarter of respondent
No,
was
in that case also the authority was located in some other state.
But one thing, if the
In fact, clause 1 of the article
authority
226.
at Delhi had no role to play in your dismissal, what happens?
Then why you are filing?
Rule 128 is 28.
No. Give us justification of filing a case in Delhi. The record is not in Delhi.
Record in Delhi as per Rule 128. The record has to be
at your headquarter.
Record is
Only because the council is in Delhi.
No, Lordship, as per Rule 128, the record has to be transferred to the chief law. Lordship, just have Rule 128.
I was discussing.
Rule 128, the record of the concerned person has to be transferred to the chief law officer.
Where do you find it?
Yes, 128, Rule 128 BSF rules. If Lordship would allow me, I'll.
Is it part of the SLP?
Please read it.
Yes, I'll read.
Which Madam, BSF Act?
BSF.
BSF
It
Act?
says preservation of proceedings. The
Where
proceedings.
you are reading from?
I have a soft.
Or you have a copy?
I'll just read it so short.
Ah.
Rule 128, preservation of proceedings. Proceedings of every court shall, after promulgation, be forwarded to the office of chief law officer and be preserved there for not less than 7 years or until the sentence awarded by the court has expired, whichever is later. That is preservation of records, madam.
That's how the record is transferred to the chief law officer who is located in Delhi. Moreover, Lordship, the petitioner is the resident of Delhi, is the resident of Uttar Pradesh. West Bengal, the first order was passed. Jammu Kashmir, second order was passed. Still, that those High Court would not be more for convenience for this particular person.
Why he was removed?
He was removed.
Not for you. The point of forum convenience is considered in relation to the inconvenience or difficulties to be faced by the respondents.
Even that's also, Lordship, this particular case has to be decided by the record. That record is available in Delhi. No witness is to be examined in that case. The case has to be decided solely on the basis of the record.
You have to show that the officer who has been impleaded as a party
Lordship,
had something to do. And you will not succeed in your writ petition. You have not made the IG and the commandant party.
Lordship,
They have passed the order.
BSF,
They have passed the order.
BSF has been.
And you know, you have not even
BSF has been made the party.
No, Director General BSF is a party.
Correct, Lordship.
BSF is not a party.
So that
Where is BSF a party? You have not even made BSF a party.
Lordship, when the man
Union of India Secretary Ministry of Home had nothing to do with your dismissal. Director General BSF had nothing to do with your dismissal.
CAP falls under the general jurisdiction of the Home Ministry.
Well, it's Rule
Director General
28A.
BSF has been made the party who is the Supreme.
Rule 28A that my colleague was also relying on. 28A also, my lords, he's an enrolled person. So for him, my lords, the petition has to go to Inspector General.
No,
28 capital.
28 capital A. This is what he was also placing.
In fact, Lordship.
No. 28A.
It can be both.
No, he is a constable, my lords.
You will have to go either.
He is an enrolled person.
Kashmir High Court or the. What was the charge, madam?
Second marriage, my lords.
Second marriage.
Yes, my lords. It's contrary to rules, my lords.
With that one.
Huh? It's personal law.
My lords, but it is not permissible under
The-
the service law.
The service.
He has to take a permission.
Yes, my lords.
So he did not take that permission. So where did he get married?
My lords, that details.
Where did you get married?
The girl which is alleged with whom I
Malda.
had come to the town of the petitioner in Uttar Pradesh.
Wherever he said
from
so.
West
He is
End.
a resident.
That was your defense in the charge sheet.
Yes, that's my defense.
Shows that you got married in, then that cause of action will arise in Allahabad.
It's registered, marriage is registered in UP. That's
In
also
Uttar Pradesh.
coming in the dismissal order.
Then
The girl
that-
is a resident.
If that is the cause,
Yes, my lords.
if that is the cause for his termination,
Yes, my lords.
then Allahabad High Court has jurisdiction.
Lordship, the charge sheet was not with respect to second marriage. The charge sheet was only with respect to abduction of that girl. So even the
Where
charge
is
sheet
the
was,
charge sheet?
that's not the part of the record. Lordship, it is for the limited
If it is
purpose.
not- If you want to get some relief from us, you will have to place all the documents.
If Lordship would say will permit, then we'll file that
Next Friday.
next.
We'll have it next Friday. You file it by next Wednesday.
Please.
If you can show that you got married in,
That
Uttar
dismissal
Pradesh?
order is showing that the
That is fine.
registration is
go
in
before
UP.
the Allahabad High
Let
Court.
him go before Allahabad.
Lordship, my humble submission is with reference to clause 1 of Article 226, which says that if the authority is located within the territorial jurisdiction of the court,
We are accepting that, but the authority has done what in your case?